The state said, we don't have to listen or respond to you, to these grievances, job-related grievances from these public employees, because of this, state law. Well, that case went all the way to the Supreme Court, and the Supreme Court said, in this context, the government does not have to listen or respond to petitions for redress of grievances. So the judge cites that case. There's a legal doctrine called Starry Decisis, S-T-A-R-E, Decisis. What it says is this: if there's a principle of law laid down in one case, that principle of law applies to a later case if the facts and the legal arguments and the law are the same or similar between the early case and the later case. That's this principle of stare decisis. So this judge says the government doesn't have to listen or respond. That's a principle of law laid down in this Smith, 1979 Smith case. Well, hold it, Judge. The facts are so different. They're not even near the same. We're not public employees complaining about job-related grievances subject to state legislation. We are citizens. We're complaining about the government's violation of the War Powers Clause, the taxing clauses, the money clauses, the privacy clauses. The facts are so different. And, Judge, there's an argument here that we're resting on that did not come up in that other case. So the law is different. The argument is the original intent of the founders. Judge, we said, based on the historical context and purpose, the original intent of the founders in putting the words in the Constitution, the government has to respond based on this the interpretation that we've come up with here, which rests on this historical context and purpose. We said to the judge, there is absolutely nothing in American history or jurisprudence that contradicts this interpretation that we've come up with. Nothing, including the Smith case. What? This was an action for declaratory judgment. They couldn't dismiss it for lack of standing. It's a difference. You can't dismiss an action for declaratory judgment for lack of standing. We want a declaration of our rights under these last 10 words and a declaration of the government's obligations under those 10 words. So they couldn't weasel out with some lack of standing, so instead he dismisses it on the judicial doctrine. It's a judicial doctrine, the stare decisis doctrine. So we appealed it to the Court of Appeals. And in the meantime, we're screening these films all over in early 2006. These are just some of the scenes. That one on the right, the line, we screened it in Hollywood. The line was all the way around the block. There's only 450 seats in the theater. And Aaron was there. And there he is talking to them. And we had to say to the people outside that we'll have another showing. If you'll come back, we'll do it again. So most of them came back. We had 2 showings. But it was powerful. We wanted to kickstart, jumpstart America, freedom to fascism. So we just went out and rented these theaters. And that's Medford, Oregon on the left. I remember that room. Not sure where that is on the right, but maybe Chicago. There's Aaron doing a radio show in Chicago. Okay. What happened here? Whoops. Didn't mean to do that. Sorry. Not sure, I might have to wait for those to finish running. Okay, in early 2007, we had another one of our national conferences on the state of the Constitution. And in November of 2006, how many here have seen the movie V for Vendetta? Wow. Good. Those of you who have not seen it, go rent it this weekend and watch it. It is powerful. It's a very good movie. And there's a character in that film that has a mask because he was burned beyond recognition and terribly scarred. So he wears a mask and a costume. And there's a powerful scene in that movie at the end. And Remember the 5th of November is a theme in that movie, and it's Guy Fawkes Day, and it's sort of like a holiday over in England. It turns out in 1600 sometime, this guy Guy Fawkes tried to blow up the Parliament, and he didn't succeed, and he tried to do it on the 5th of November. And anyway, this movie takes place, I won't give the movie away, but it takes place in 2015 in England, and England at that time, just a few years from now, is a real police state. And it's the government in total control and constantly feeding the people through the television that there are terrorists out there, and sorry you have to give up your liberties for security, but we need you to do that. And they actually stage an event. They didn't knock any buildings down, but they poisoned a lot of, government poisoned a lot of kids in a school. And they blamed it on terrorists, and that's why we have to give up some of your liberties and whatever. But the character in that movie, V, for Vendetta, in November 5th of 2006, I faxed a note to the White House and to the leaders of the House and Senate, saying that on November 5th there would be a person in a mask and a costume appearing at the security checkpoints at the White House and at the Capitol and at the Department of Justice. And the reason he'll be in a mask and a costume is because he's giving expression, First Amendment right of free speech, he's giving expression to the fact that we're becoming a police state. And he's using this character to get that point across. And you make the connection with the movie, you understand why. And so and that he will be showing up and presenting all the petitions for redress of grievances in yet another attempt to get the government to respond to the petitions, violating the war powers clauses and so on. And so on, I'm just not into theatrics, and I felt very silly when I left the Washington Plaza dressed as this character. And I had a young lady following me with a camera, videotaping everything. I felt really silly until I got 2 or 3 blocks into this, and I started feeling better as people reacted. Just ordinary. I had to walk 5 blocks to the White House, and you would hear people say, "Hey, V," like they saw the movie. Another guy would come up to me and say, "Are you an actor?" And I would say, "Did you see the movie V for Vendetta?" He said, "No, are you in it?" I'll go watch that. And as we got close to the White House, it just so happens, by coincidence, Cindy Sheehan was down there with an anti-war demonstration, so I had to walk through her crowd. Didn't say anything. But a lot of them said, "Hey, V," and so I got over to the security checkpoint, and I had the petitions for redress. And so and the guy said from the shack, "Can I help you?" And I said, "Well, I've got some petitions to serve here on the president." And he said, "Put them in the mail." And I said, "Well, we tried that a couple of times. It doesn't seem to work." So he said, "Well, you got to put them in the mail." Well, I went like this, and around the White House there are these wrought iron fence, and there's a concrete wall at the bottom, so these wrought iron rods come up out of the wall. And so I placed them between and walked away. Well, the whistles blew. People blew their whistle. And just like that, there were 15 Secret Service agents coming on bike, on foot, by car. They were all there. And all of this is being recorded. You do the right thing, you never know what's going to happen. Just do the right thing. Stand on your rights. Don't be intimidated. Don't be smart alecky. Don't be abrasive. but screw up a little courage sometimes. You never know what's going to happen. So what happens? So as part of the V for Vendetta costume, those of you who have seen it, there are these daggers. There are 6 of them in his belt, right? So one guy comes over and says, oh, they're plastic, they're okay. And then someone says, well, take your mask off. Oh, we said, what are you doing here? And I said, well, we did fax a note and say we were coming. So the guy, he said, you did? You have a copy of that? And I took out, and he backs away, and they all have microphones under their collars. So he's talking into his microphone, and he's taking notes. And it's the actual fax telling him I would be there, what I'd be doing. I had a permit. They didn't know this, but I had a permit from the National Park Police to do this. And I'll tell you, I also went to the city. You know, I was going to go from there, and then I was going to march over down city streets to the Department of Justice building and serve them the same papers by custom. And that means you have to walk down city streets. When you're at the White House checkpoint, you're on National Park Police, National Park Service land. So you get a permit from the National Park Service to be there. And so I went through the whole process, said I'd be there, this is what I'll be wearing, and I'm in costume because I'm giving expression to the fact that we're becoming a police state. Freedom of speech. When I went to the Special Operations Unit at the department, at the DC Police Building, to apply for the permit, the clerk there, in uniform, she said, oh, we have a law on the books that you can't wear a mask on the city streets. I said, well, what do you do at Halloween time? And all these kids. Said, well, you know, that's different. I said, well. So I said, can I appeal your decision? Who do I appeal your decision to? And she said, well, just a minute. So she called, and the head of the Special Operations Unit is a captain, and he came down, and he had the law book, the law in his hand. And he said, what do you want to do? And I said, well, did you see the movie V for Vendetta? He goes, yeah, that was a great movie. So I said, well, that's all I want to do, is wear that costume and go serve these papers, you know, on the White House and on Congress and on the Attorney General. So he said, well, we do have this law in the books, you know, that we put in place years ago to keep the Ku Klux Klan from marching. I mean, what member of the Ku Klux Klan is going to march if he has to take his hood off, right? So that's why that law is on the books. So he said, well, let's take another look at the law. He said, well, it says here, you know, it starts out saying you can't wear a mask on the city streets, but it goes on and says, if you're going to intimidate or commit a crime or something, you're not going to do any of these things, are you? And I said, no. He said, here's your permit. You like the movie. You never know what's going to happen. See? And so I had this permit, and we were down at the White House, and all these guys, apparently the word doesn't get around. The left hand doesn't know what the right hand's doing, apparently. And so the guy says, well, you know, take your mask off. And I said, no, I can't do that. I mean, that would defeat the whole purpose of giving expression to the fact that we're becoming a police state. You know? And so the 2 of them get in an argument. 2 of the Secret Service people get in an argument over whether I have to take my mask off. And one guy finally says he doesn't have to take his mask off. So I won that little debate. And another guy says, what's your Social Security number? And I said, now you've really gone too far. You know? And they get in an argument. 2 of them get in an argument. And I win that one. Somebody argues on my behalf. He doesn't have to give his Social Security number. And then I feel somebody on my arm. And I turn around, and it's a guy holding my arm down, and he's taking these daggers out of my belt. And I told him to stop, but he wouldn't. And he said, I don't know how well trained you are in the use of these. I said, they're plastic. You saw the movie, of course, and V for Vendetta in the movie is very skilled with these daggers. So anyway, he's throwing them on the ground, and I'm arguing with everybody, staying calm, but prevail, and then it's time to leave. I'm allowed to leave. And I said, so this guy's holding my 6 daggers. I said, I'd like my plastic back. So he says, you should really maybe put them under your cape, but in your belt, a sash, but behind, out of view. And I said, hold it. That's a concealed weapon. I want them out front where everybody can see it. Sure enough, two of them got in an argument. And I won that argument. Not I, but somebody won it. You know, somebody else won it for me. So anyway, I got the daggers and left, and went down to the Department of Justice building. And there's a. I've been there many times to serve legal papers. And there's a guy out front, and so I walked up with the costume, and and I said, I just want to serve some legal papers. And starts talking into his microphone, and all these folks come. This time it's Homeland Security. And anyway, he gets on, one of the guys that gets on the phone with the DC police and finds out that I have a permit and that everything's okay and I'm allowed to go. But in that transmittal letter, we said we would be there, a single V, and if the government continued not to respond, then we would be back in larger numbers on the 14th of November. And the 14th of November, powerful sight. There were 60 of us, not shown here, but the imagery is very powerful. You have 60 Vs standing facing the White House in a silent vigil, just standing there saying nothing, letting the signs speak for themselves. And we had a 45 by 25 foot banner that said, no answers, no taxes. We had another one that said, dear government, obey the Constitution or else. And then we had these hand signs saying those same things. But it's just silent vigil. I mean, there are a lot of demonstrations down at the White House, but obviously some effort went into this, and these costumes, are not cheap, right? So nothing happened. Then on our 2007 national conference, on the Friday, March 30th of 2007, there's now 130 of us in costume. We bussed over from the hall where we were holding the conference, and we lined up outside the White House with our banners and so forth. Image, beautiful day, a lot of tourists causing, a sight. It's powerful imagery. And the White House is not very far away, and obviously they saw this. And to this day, I just know that either Karl Rove or Dick Cheney or the president got on the phone to Gonzales and said, doggone it, we told you, you said this was under control, we told you to shut this effort down, What's going on here? They're getting larger and larger out there. Well, on that particular day, the Washington Post showed up. And I think you never know what's going to happen. He wasn't there for us. He was at the White House. He's part of the White House press corps. And so he was coming out of the White House, and he came upon us. And he found out where I was, and he was talking to me, and he's getting the story. And he ran a photo and a little article in the Washington Post. And the headline was, agitating for the First Amendment. And he got the story right, that there were other issues, constitutional issues, and we're agitating for the First Amendment right to petition. The next week, the government sued us, and they just manufactured this stuff, and it was over our blue folder. They had to choose something, but they sued us, and we're dealing with that. It's not a big issue. The U.S. We the people now, they're fighting back. It was we the people versus the United States. Now it's U.S. we the people. They sued the week after, sloppily put together complaint. You can tell it was done in a hurry, and they sued. And it was shortly after that that the Court of Appeals issued its decision in our right to petition landmark case seeking a declaration of our rights under the petition clause. The Court of Appeals issued its decision, and we filed our writ of certiorari with the Supreme Court. The Court of Appeals decision, they cited both the Smith and the Knight case. We talked about the Smith case already. What's this Knight case? In Minnesota, the Minnesota legislature had passed a law that said, public employees, if you have grievances on the job, you must submit them through your collective bargaining unit. You have a union, you must use it. Quite the converse of what was going on in Arkansas. And so in Minnesota, you had college professors who were employees of community colleges owned by the state. And they did not want to submit their grievances through the union. They wanted to submit it directly. And Minnesota said, no, we don't have to listen or respond to you, you know, because the legislature, yeah. So that case went all the way to the Supreme Court, and the Supreme Court found for the state again. This time, the government doesn't have to listen or respond because you've got to go through your union. So here you had the Court of Appeals in saying we're bound by these two earlier decisions by the Supreme Court. But something interesting happened in that case. One of the three judges, Judge Judith Rogers, wrote a separate 9-page decision in which she said, I don't know why it was a concurring opinion, it should have been a dissent, but what she said in effect was, hold everything. The facts of this case are different than those other two cases, and these people, meaning us, we're arguing something that was not argued in those other cases, she said, because I checked the briefs that were submitted to the Supreme Court, and the original intent behind the last 10 words of the First Amendment were never argued in those two cases. So what do you mean, stare decisis, you know? And she said, it will be interesting to see how the Supreme Court handles this matter. This is one of the three judges in the D.C. Court of Appeals. It'll be interesting to see how the Supreme Court handles this matter. So we prepared the writ of certiorari and submitted it, asking the Supreme Court to hear the case. And in January 7th of this year, they decided they didn't want to hear the case. Now, this is the First Amendment to the Constitution. It's the it's a case. It's what they call a first impression case. No court has ever declared what it means. What are the government's obligations to respond to the people when they have evidence that you're stepping outside the boundaries and they call you on it? And they petition for redress or they petition for remedy. What is the government's obligation? No court has ever declared that. We only had two questions before the court. Does the government have to respond? And if they don't, can we not retain our money until they do? Can we not withdraw our financial support, if not our support altogether? Because they've stepped outside the boundary, they violated the compact. What does a free people do? This is a non-violent solution to a problem. Our evidence shows us that the founders put that clause there as part of the carefully crafted balance of power between the people and the government. What other non-violent way is there to hold the government accountable? If they do whatever, they start doing whatever they want to do, the Constitution be damned. What else is there? There's no other non-violent way. The founders knew that, as we're going to find out here in a minute. They knew that. Anyway, in 2007, we got involved in the election issue. People came to us, and it was a growing concern of ours. And then when people come to us, we don't know how to say no, and so we got heavily involved in that issue. And then when the Supreme Court decided on January 7th not to hear the case, under the Supreme Court rules, you have the option within 25 days of filing with the Supreme Court a petition for a rehearing. Hey, don't you want to reconsider this? You made a big mistake here, you know, and you argue why. Well, I believe we have to exhaust every opportunity, every judicial opportunity. You're building a record. You know, there's a record that's being established here. Let it never be said in any case that we're involved in that we did not exhaust our administrative and judicial remedies. We never want to put the government in a position of saying, well, geez, had you only filed your petition for rehearing. You want to take it all the way. You don't want to quit. I know it's hard. So we filed our petition for rehearing, and just recently, it was the 25th of February. They said they were not going to, they denied that and were not going to hear the case. Pretty serious matter. This is the Supreme Court's primary role, is to interpret the Constitution and to keep the other two branches in their constitutional places. That's their primary job. Co-equal, independent branch of the government. What else are they there for? And so in this petition for rehearing, I was able to hang them on there. I've never talked so, I wanted to, so straight to a court. I didn't want to threaten, I didn't want to get abrasive, but I wanted some straight talk, you know. And so I was able to hang them on their own petard, in a way, because in 1821 or 1824, they decided a case called Cohen v. Virginia. And in that case, the Supreme Court went on and on about, they don't have to hear all cases, but if they don't hear a case that they should hear a case, when they should, that is treason to the Constitution. They said so in their own decision.
Wow.
They said that in their decision in 1824. And then I was able to quote Judge Ruth Bader Ginsburg, one of the Supreme Court justices, in my petition for rehearing. I'm saying, look what Judge Ginsburg said recently in the Anna Nicole Smith case. She quoted from that Cohen v. Virginia case. You know, there's some criticism. Why is the Supreme Court hearing the Anna Nicole Smith divorce, probate, bankruptcy case? Why are they hearing junk like this? Well, we know why. It's all over the news. Everybody's interested. And so, but in that Anna Nicole Smith decision, Judge Ruth Bader Ginsburg quoted from that case, and she said, probably because they felt they had to respond to some of this criticism about why they're hearing this case, she quoted from that case and said, you know, if we don't hear a case when we should, that's wrong. There's an ellipse in there. She leaves out the words, it would be treason to the Constitution. She leaves that out, okay. But anyway, I put all that in there, right? And I also said it would be shameful for the court not to hear this case, given what else they hear, the other, you know, cases of less importance. I mentioned the Anna Nicole Smith case. There was a case decided very recently that the Supreme Court heard. It just grates. There was you know how on television there are these judges that, for entertainment purposes, they're deciding low-level civil cases for entertainment purposes. Well, there's this judge, this TV judge called Farrar, Judge Farrar, F-E-R-R-E-R. And so he had a dispute with his lawyer over a fee. And in their contract, there was an arbitration clause. So the judge said, no, that doesn't have to go to arbitration. When the lawyer said, yeah, that's going to be arbitrated. And so that case went all the way to the Supreme Court. And the Supreme Court said, you know, that that has to go to arbitration. Sorry, Judge, you're wrong. You know, Supreme Court hears garbage like that. Doesn't affect the rest of us. And they will not hear this case. They will not. Why? There's got to be a reason. Why? They don't want the government to be held accountable. They're part and parcel of. They're cooperating with the other two branches in a collective decision to deny us our constitutional rights.
Treason. Treason.
And they don't want to be held accountable. That is the accountability clause, as we'll see. And then we had this primary recount up in, this is our final report. You can get this entire report from our website. It's our report on the New Hampshire primary recount. It shows, without question, that New Hampshire was a great laboratory. It's why we were so interested. In New Hampshire, everybody votes on paper. That's great. But in New Hampshire, 80% of those ballots, hand-marked, get fed into optical scan machines, and the vote is counted by machine. The other 20% are still counted by hand. Great. So it's a great opportunity to be able to compare the performance of machines versus hands. That was our interest, right? So we did that. And you'll see in here that we have a few findings. First of all, and the machine that they use, in New Hampshire, the Secretary of State certifies the machines, and they've only certified one type of machine. It's the optical scan machine. It's the machine, optical scan machine, that the country is gravitating towards. So it's a pretty important case. I mean, pretty important what's going on up in New Hampshire. And so we analyzed all the data and so forth. We're there for the recount. And what did we find? We found that the machines, that the federal government has standards for accuracy in vote counting by machine. They have standards, accuracy standards. The machines in New Hampshire violated those standards. Basically, the standards are this. You're only allowed one error in 500, as the machines read 500 ballot positions. So over 500 ballot positions, and there were 21 Republican candidates and 20 Democratic candidates up there. As it reads 500,000 votes, it can only have one error. Those machines violated that standard 163 times. The error rate was 163 times what is allowed by federal standards. Pretty important. Also, the size, so the frequency of the error